Well, thank you very much for joining me on this video. I want to talk to you today about signing documents, signing a listing or signing an agreement of purchase and sale. Who should sign, under what circumstances? And we're going to start with a matrimonial home. I had an agent ask me the other day, said, I have a client, a woman, and she purchased the house when she was single. Sometime later, she got married, her husband moved in, it became the matrimonial home. Now she wants to sell. Does she require his consent? And the answer is yes. It doesn't matter that she owned it before she was married. It doesn't matter that he doesn't have any financial involvement in the property. Under the matrimonial home, under the Family Law Reform Act, it requires the spouse's consent to encumber or dispose of the property. So he has to sign off, or she can't sell, and she can't increase the mortgage, she can't put a new mortgage on, and so on. I thought at the same time maybe we'll talk about some other circumstances where signatures are required, and it can be a little bit confusing who signs and how they sign. So let's talk about estate sales. Let's suppose you have a husband and wife, you have a matrimonial home, the husband passes away. The wife wants to sell the house. How is it set up on the listing, and who signs? Well, to start with, the property is either held as joint tenants or tenants in common. Almost always with husband and wife, it's joint tenant, which has the right of survivorship. What that means is when the husband dies, instantly the property reverts solely to the wife. It doesn't matter on Geo Warehouse or down the registry office, it shows his name. His name doesn't enter into it. His estate doesn't enter into it. It's her name. She has total authority to sell, to encumber. She just signs it. That's when we have joint tenancy. If under the unusual circumstances it's tenant in common, which is what would be the norm for two partners owning a property, it's totally different. Then when the husband dies, his share goes into his estate. The wife doesn't have the clear and absolute authority to dispose of or encumber the property. She's involved, she will be signing, but it's she and his estate. So on a listing, it would show the lady's name and the estate of the husband's name. And we would have to then look at the will to see who the executor is, and the executor is the one who would sign for the estate. When it comes down to signing, you'd go down to where they sign, and they would sign their name, not the deceased husband's name, and underneath they would say executive for the estate of, and they would print that under their signature. One thing you as a realtor would need to do is establish, yes, in fact, they have passed away. You need to have a look at the death certificate, and then you need to have a look at the will to make sure you know who the executor is, and then for FINTRAC, you need to identify the executor. All right, what about power of attorney? The person isn't dead, but they've assigned power of attorney. Somebody else has signing authority. Well, here the listing would show the vendor or the seller as who the name of the person who owns the property, who's on the deed. But when it comes down to signing, the person who has the power of attorney would sign their name, and underneath they would print power of attorney for, and then the name of the actual owner. I want to stress that you do, I should say here, they need to take a look at the paperwork and make sure that in fact they do have a valid power of attorney. And I want to stress finally that under no circumstances does the person, whether it's the executor or whether it's the power of attorney, sign their own name. They always sign their own name. They never sign the name of the person they're actually standing in the shoes of or representing. And that's unusual. Years and years and years ago, the Law Society taught their lawyers to sign the person's name. Now, generally taking the assumption that that's fraud. And in fact, we had a situation one time where the agent didn't understand, and they had express authority to sign on behalf of the actual owner, and they signed the actual owner's name, and RICO ended up fining them heavily and realizing it was just an honest mistake. It wasn't fraud at all. So you've got to be careful about that. You never ever sign anything else than your own name, but you need to clarify whether you're signing it as power of attorney, whether you're signing it as executor, and for on whose behalf. Hope that is not too confusing. I appreciate you investing the time to watch this video. I'll talk to you again next week.